Now, the third requirement is it must meet the test of utility. Now, this is more interpreted to be a statutory requirement. That is, the invention has to fall into, for utility patents, one of four categories. The first is a machine, such as a motor or a computer. The second is an article of manufacture, such as a transistor, a diskette, a new capacitor or inductor, or a toy. The third is a composition of matter, such as a pharmaceutical or a chemical. And the fourth is a method or process, such as the most common ones are methods or processes of making chemicals or pharmaceuticals. I think one of the first patents that was issued was a process for making salt. Recently, though, there have been methods of doing business patents which have become a patentable subject matter. We'll talk about that in a little while. The courts were rather hostile toward according protection to computer-based inventions and software-based inventions. I should say software-based inventions, not hardware-based inventions. Software-based inventions in the first half of the 20th century. The first case that I quoted in the outline was Gottschalk versus Benson. It was decided in 1972 by the Supreme Court. Justice Douglas had written the opinion, and the invention was a method of converting binary coded decimal numbers into pure binary numbers. And the court held that that was not patentable because the sole practical application of the algorithm was in connection with the programming of a general purpose digital computer. So what Justice Douglas was effectively saying is, if it's an algorithm, it's used to program a general purpose digital computer, not patentable. He didn't like it. The others, he had enough votes on the court to agree with him. Interesting, at the time, a number of the hardware manufacturers filed a friend of the court briefs with the court, and they supported the patent office to reject this claim on the ground that it should be non-patentable subject matter. The statute doesn't provide for any protection. The hardware manufacturers may have felt at the time that if you provide some exclusivity to software, it might detract from the general purpose use of the hardware. As time went on, they began to realize that the more they promoted software, the more usefulness their hardware became. So, in fact, I note from reading the case that one of the briefs that was filed against patentability of these types of inventions was by IBM. Later on, they kind of saw the light. Now I think they derive more revenue from their software than their hardware business. But at the time, though, it was greeted with enthusiasm by hardware manufacturers, but legal scholars criticized it severely. Donald Chisholm, who authored a very famous treatise in patent law, stated that the decision was based on a very anti-patent opinion of the court. I recall my professor in patent law and law school stated that Justice Douglas was not noted to be a friend of the patent system. Well, so be it. Technology evolved, and I think as things were progressing, the industry itself was almost crying, screaming for some sort of protection, because as technology began to evolve, there was a demand for some protection for the exclusivity. Well, as I mentioned earlier, the copyright statute was enacted in 1976. Statute went into effect in 1978, and some people thought, well, okay, computer programmers, you got your copyright protection. What more do you want? Well, they wanted more. Well, in 1981, another case came before the Supreme Court, which was Diamond versus Deere. This was sort of like the beginning of sort of the trend. I don't know if you can say it's sort of like a binary 0.05 or something like that, moving toward a little bit away from the hostility toward patent protection for software-based inventions. This case involved a method of, it was a method of operating a rubber molding process for precision molded compounds, and it was with the aid of a digital computer. The inventor filed its application with the patent office. The examiner examined the application. I'd like to spend just a little bit of time on this case and might give you some sort of idea as to the patent process. In a patent application, you must describe your invention according to the statute with sufficient particularity to enable anyone having ordinary skill in the art to make and use the invention. You have to describe the invention clearly, and that's your contribution to the progress of the useful arts, so that other people can learn from you and invent. Okay, that's all well and good. At the end of the patent, there should be something that provides some objective criteria to determine whether or not your invention meets the tests of novelty and non-obviousness. Now, this was a method of operating a rubber molded press, and let's assume for hypothetical purposes, I hope that this is visible, that at the end of the patent, the applicant inserted as a claim, claim 1. It's a statement of the invention in the object of a sentence, and it's a of operating a rubber molding press for precision molded compounds. The examiner would then do a search for all prior patents and publications. And even though the invention may have had a lot of elements, if the examiner found this in the prior art, a method of operating a rubber molding press for precision molded compounds, the examiner would reject that claim on the ground that it lacks novelty and is obvious over the prior art. The applicant then has a right to a claim to define the invention more specifically, and that's what the applicant did. The applicant then amended the claim to define the invention more specifically. Now, this was a method of operating a rubber molding press for precision molded compounds with the aid of a digital computer comprising. And then there was a number of steps that were inserted there to conduct the method of molding, which used Arrhenius's equation. Now, everyone agreed that Arrhenius's equation was not new. Arrhenius's equation was old. And the computer would obtain data based on Arrhenius's equation to program the computer to control the process. In fact, the claim actually included Arrhenius's equation. Natural log of V equals CZ plus X, where V is the total required cure time. I think C is an energy constant, which is unique to each batch. Z, the temperature at the mold at a location closely adjacent to the mold cavity, and that's probably one of the variables. That is the variable. And then X is a constant dependent on the geometry of a particular mold. X would change with each batch. So the inventor used Arrhenius's equation, well known, to program a general-purpose digital computer to perform this process to produce molded rubber.